the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Hello, everyone, and welcome to the Fair Housing Insiders Case Files, Episode 22, with Leslie Tucker, the principal of Williams, Edelstein, and Tucker. I'm your host, Jonathan Sarr. Today's case, we have a situation of a case of a medical emergency that was misunderstood and resulted in a housing authority proceeding with an eviction before getting all the facts. Leslie, what resulted when the truth came to light?
So, Jonathan, the individual who HUD filed this case on behalf of is a disabled individual, which the housing authority, the management agent, was aware of. His name is actually redacted from the complaint in this case. So, for purposes of this explanation, we'll just call him Tom. Tom suffers from diabetes and a heart condition. The incident that makes up the basis for this complaint occurred when Tom alleges that he was experiencing a medical crisis. He had very low blood sugar, which he claimed made him very disoriented. And he went to go walk to his mother's house, who lives approximately a mile away in another apartment. However, because Tom was so disoriented, he could not find his way, and ended up having to knock on some of his neighbors' doors to ask for help. Because this was in the middle of the night, his neighbors were, understandably afraid, confused what was going on. And two of them called the police, who responded and helped Tom get back to his apartment. The following day, he did go to the hospital where he was treated for a medical issue, the medical issue that he claims he was suffering from the evening before. A few days later, management, the defendant, allegedly issued a lease termination letter due to his in quotes, behavior of physically threatening the safety of the residents. It was noted in the complaint that there was never kind of any claim or allegation that threats occurred, that anyone's safety was, in jeopardy, but rather sort of the fear of someone knocking on your door in the middle of the night. Tom appealed that termination, and an informal hearing was held, after which the termination decision was upheld by management. And eviction proceedings commenced. The property prevailed, and then Tom appealed that as well. He got an attorney, and he made a request for a reasonable accommodation to remain in his apartment. He explained that he was making efforts to keep his medical condition under control, and they provided a letter from Tom's physician. Several months later, the defendant did opt to dismiss the eviction case and to go ahead and allow Tom to remain at the property, sign a new lease, and so they offered him a renewal. Tom did ultimately sign a new lease, but ended up vacating, a couple of months later, citing his fear that management would just file another eviction against him at any moment. HUD investigated this. They found reasonable cause to believe that a violation had occurred here, hence, why this case was filed with the HUD Administrative Court.
Interesting. Lots of detail there. Thank you for the explanation. So just looking back on the case itself, You mentioned a resident's knocking on the neighbor's door. That was part of the criteria that management considered it a lease violation. So does this mean that this type of behavior, so specifically middle of the night, someone knocks on the door, could this behavior, or should it be, overlooked?
No, not necessarily. And I don't think that is what we should take from this case. Lease violations are lease violations, whether they are disability related or not. However, the level of consequences should vary depending on the circumstances, depending on, the egregiousness of the situation. And if a known disability is involved, yes, I mean, this should be taken into account in deciding how to handle it. If you're dealing with kind of a minor first time incident, perhaps a violation notice may not be warranted. Maybe, a warning notice or something may be warranted instead. So, I think it's important to remember that you are still permitted to enforce your lease, regardless of whether someone has a disability or not. But it's also important to remember that, yes, that disability should be a factor, especially if you are aware of it, especially if the resident makes it known that they have a disability and this is potentially disability related behavior. That should be part of the equation as well as you're determining, consequences for actions.
Okay, very good. Thank you. So what are some ways, thinking from our community's perspective, outside looking in, what are some ways management can respond to an incident when a violation occurs and it's due to a disability?
Yeah, so if someone's behavior that violates your lease is, disability related behavior, depending on what it is, depending on what the behavior is or the conduct is, sometimes a violation notice may still be warranted, even if it is disability related. At a minimum, there should be some kind of incident report for your file. So the incident is documented. You're keeping good documentation, which is always important. Perhaps a meeting with the resident is, an appropriate thing to do after an incident occurs that is disability related. I think it's appropriate and proper to ask for assurances that this type of incident would not occur again. Perhaps asking what actions the resident is taking to ensure that that type of behavior does not occur again. If a resident is not taking any action to change that conduct, and that could be, seeing their therapist, it could be changing their medication, it could be ensuring that, someone is monitoring their medication. There could be a, variety of ways that someone can ensure that their behavior is not violating their lease or disrupting other residents, quiet enjoyment. But it's important that they do make those assurances if they are violating their lease, that this is not going to just continue to happen. If they have made assurances, if they are taking, good proactive steps, then you have reason to give them additional chances as a reasonable accommodation. If they're not, and if they have they're showing kind of no interest in taking those proactive steps, you may be less inclined to give them those additional chances to cure their violations. And of course, if a reasonable accommodation is specifically requested from a disabled individual, then yes, those conversations, those communications have to happen as part of that process. And, you have to issue a written response after you get an RA request. So that would be a little bit of a different situation. But ultimately, again, as I said, taking that disability into account, potentially giving those extra chances if it's warranted, would be appropriate.
Very good. Thank you for the explanation. Again, another good case, one for our community to just take a look at it from a granular perspective, and appreciate your insights, Leslie, on this particular episode. So thank you again. Thank you for everyone who tuned into our show today. This has been the Fair Housing Insiders Case Files, episode 22. Thank you, everyone. We appreciate you. See you next time. Take care.